Okay, today I'm joined by Calum Thwaites, who is a student. He is now a human rights advocate, and he's at the centre of the now notorious 18C QUT case. So how you going, Calum?
Yeah, I'm not too bad. Thanks for having me today.
Yeah. Great. So I think your case is probably the best demonstration of what is wrong with free speech in Australia today, not only from the perspective of free speech itself, but the problems with the law, 18C that is, and the processes of the Human Rights Commission. So what I'd like to do is start at the beginning, because this whole story really encapsulates all of that. And I'd like to read a post that you put out, a tweet actually, back on the 28th of May this year. And if I could just get it up here. You said, today is the 4th year anniversary of Alex Wood writing QUT Stopping Segregation with Segregation on Facebook.
Yeah.
So that was 28th of May this year. So can you take us back to the 28th of May 2013?
All right. So on the 28th of May 2013, 3 students at QUT, one of them being Alex Wood, who was an engineering student at the time, were looking for computers to use to study. They went into a relatively new building and stumbled across a room that had computers free for use in there. No signs on it saying that they couldn't use it. So they went in and started using the computers. Then an administration officer of QUT came up to them, asked them if they were Indigenous. They said no. She then informed them that the room was for Indigenous students only and that they had to leave. So they did. They left. They didn't make a fuss. About 45 minutes after that, Alex finally found a computer, logged on, went onto Facebook, onto a Facebook group, and posted, just got kicked out of the unsigned Indigenous computer room, QUT stopping segregation with segregation, ? And then he went about his day. Little did he know that that post blew up. A lot of people commented on it. A lot of people were having discussions about whether segregating students based on their race is a good thing, whether affirmative action is the right way to handle things. Some people made jokes comparing the situation to if there was a white supremacist's room, how that would go down, obviously not particularly well. And in there was a comment by a Facebook profile that had my name and my picture, but wasn't set up by me. This comment used a word that a lot of people find quite offensive, rightly so. And as a result of all of these comments, the woman who kicked Alex out of the computer room became offended, went to the university, complained, took time off sick, and eventually instigated a process where she made a complaint to the Human Rights Commission about 7 students, 2 staff members, and the university under Section 18C of the Racial Discrimination Act.
Before all that, the university actually contacted you about the particular post that was allegedly done by you because it had your name on it. So, and what did they say?
In the process of this woman complaining to the university, the equity director of the university contacted whoever they could find from those comments whose name matched up with a student at QUT. I believe she messaged or emailed Alex, one of the other students, Jackson Powell, and she emailed myself. In this email, she said, there's this comment, it's offensive, it might breach our code of conduct, could you please remove it? So when I saw the email, I responded simply saying, I don't know what you're talking about, I haven't made any offensive comment on Facebook. I think you've got the wrong person. She said that she'd look into it, and that I shouldn't worry myself with it because I've obviously got a lot of exams going on. May's generally start of study for exams, and that they'd look into it and to leave it to them. So I took them at their word, thought the university would be looking out for me, thought they'd figure out what was going on, and just went about my business. Little did I know that they just assumed that I was lying, gave or worked with this woman to figure out information about the students, and eventually she somehow got our addresses for a number of the students and decided to lodge complaints about us. Now that's one thing, but even then we were still kept in the dark. So it took a year of dealing with the university before she decided that she'd lodge a complaint with the Human Rights Commission. So that's from 2013 through to 2014 with the university. Then from 2014, it was 14 months until any of the students were even made aware that a complaint had been lodged in the first place.
Yeah. So Alex makes the post 28th of May 2013. She tries to get some kind of outcome via the university for a year, but she doesn't. And she lodges the complaint with the AHRC on the 27th of May, which is one day, because if it's 2 days later, she's out of time, right?
Yeah,
she's got to lodge it within a year.
There's a limitation period on how long you can wait before you lodge a complaint with the Human Rights Commission, and it's 12 months. So I believe what happened is she had lawyers at this point, and they wanted to preserve her options of going to the Human Rights Commission. So they lodged the complaint while they were still in negotiations with the university about how much money the university might give her to make all of this go away.
Yeah. So she lodges the complaint on the 27th of May 2014, almost a year after. But you still know nothing about this, do you? You know nothing about what's going on.
Yeah, exactly. I don't find out until the end of July 2015 that there'd been a complaint to the university, that there'd been a complaint to the Human Rights Commission, and then that there was a conciliation conference at the start of August, which it turns out I had 3 business days between finding out about the complaint and having to attend a conciliation conference where the plan was to try to make this matter settle.
Yeah. And just to be clear, you didn't know Alex, is that right?
No, I didn't know Alex. I didn't know Jackson. I didn't know any of the students named in the lawsuit.
Yeah. You were an education student at the time. Alex was an engineering student, I think. So you guys had never met, and well, I don't know if you'd ever met. Have you ever probably run into each other on the campus, or nothing at all?
Honestly, when I first met Alex, it was the first time I'd ever seen him. And that was when this was in court. So I don't think I'd even run into him on campus. So
we fast forward. It happens in 28th of May 2013. She lodges the complaint 27th of May 2014. Now, you don't hear anything until July 2015. So this is 26 months after the actual incident. And you are told that you have 3 days to front up to a hearing at the Australian Human Rights Commission.
Yep. So the university and this woman had 26 months of working out what was going on. The Human Rights Commission had 14 months with this file when they decided that only near the end they decided that the student should be made aware. But they decided that it was okay for students who don't have lawyers, who can't necessarily afford lawyers, to have 3 days to come to a conciliation conference that's specifically kept confidential to discuss settlement and to put their case forward. Yeah. It seems a little bit unbalanced, if you ask me.
But I was under the impression, and correct me if I'm wrong, that the Australian Human Rights Commission don't they have a procedure whereby there should be a certain length of notice given before?
Well, they do now.
They do now.
Thanks to part of the failed 18C reform bill from earlier this year, some of the procedural reforms involve informing respondents and time requirements on that. Right. So hopefully this kind of failure is really what it was. This kind of failure doesn't happen again.
Yep.
Whether or not it's just a band-aid to fix a bigger problem, we'll have to see.
But isn't part of the problem is that the Australian Human Rights Commission actually has the power to throw out cases they deem that don't sort of rise to the level of the law. So, I mean, isn't one of the arguments that your case shouldn't have even got that far, that it should have been thrown out?
Yep. So they already had the power to throw out trivial or vexatious claims. That power has been reinforced somewhat in these changes, but in the 2015-2016 period, the number of 18C complaints, the number of complaints under the Racial Discrimination Act in its entirety that were thrown out for vexatious was less than 1% of the complaints. I looked at the numbers the other day, and the number of complaints that get thrown out or terminated because they couldn't be conciliated, which is how the QUT case ended, is 12%. If you look at the state body in Queensland, the Anti-Discrimination Commission, they reject 45% of the complaints they get. So there's a bit of a difference in the numbers there.
Yeah, yeah.
I think that no matter what we change procedurally, the issue is the staff and the mentality within the commission about what is a trivial complaint. And it depends on who's making the complaint. We've seen Paul Zanetti make a complaint about being called a old white man, and it got thrown out because he's a white man. If it was on the other foot, I don't think the complaint that he made would have been thrown out.
Yeah, yeah. So I guess there's a couple of things there, because people hear about cases like yours. They hear about Bill Leak case. They would have heard about the Andrew Bolt case, but I don't think people realise the extent of the amount of complaints that get made. So I heard at the Liberty Conference, for example, that and I think this was due to a Freedom of Information request from the Institute of Public Affairs, that something like 800 complaints had been made over the past 6 years. So this is something that's happening far more often than I think people suspect. And as you say, not many of them are thrown out on face value. And I've called, and you don't have to confirm this, but I've called the Australian Human Rights Commission the Australian Shakedown Commission, because even in your case, some of the respondents actually just paid. They paid $5,000. Three defendants paid $5,000 just to make the complaint go away.
Yep. So one of the big concerns about the Human Rights Commission that I have is that their conciliation procedure is kept completely confidential. Right. You don't find out the outcome of these conciliations. They might put occasional de-identified case studies up, but for the most part, it's completely confidential. You walk in and the complainant will say, look, I'm alleging that you've racially vilified me. It's all behind closed doors at the moment. But if you don't pay me the money I want, I will put it on the public record, take it to court, and then no matter what happens, you're branded as a racist, because people out there will believe what I say. Yeah. It's happened in my situation, despite both at first instance and on the appeal. Both myself, Alex, and Jackson Powell being vindicated, there are still people out there that call me a racist.
Yeah, you only have to go on BuzzFeed to find some of that. I was looking around there the other day. People seem quite happy and willing to just dismiss all the evidence. They don't care. They've just decided that you're a racist and you must have written the thing that you're alleged to have written.
Exactly.
Yeah. So it's one of those. I don't know. I mean, it's a double-edged sword. It's obviously a horrible thing to be branded, because you can't really disprove, that you're a racist. It's very difficult to get rid of that kind of moniker. But then I wonder, with the sort of gay abandon that the left throws around terms like racist or sexist these days, I wonder if they are starting to lose their effect and people just don't care anymore.
It might be losing its edge a little bit, but it's something that's going to follow me for the rest of my life. It's part of the reason that I did some interviews with Andrew Bolt or with The Australian to get my side of the story out, because otherwise it would have just been news articles and biased or misinformed or completely incorrect things from BuzzFeed or The Guardian. just to name a few.
Yeah. So going back to, and I think this is another aspect that people may not know about the law. So I'm guessing at this point that you can probably recite 18C by heart, or have you tried hard to forget it?
No, I'm pretty well versed in 18C, and before anyone says 18D as well,
yeah,
I do know that it exists.
Yeah, people like to throw that out, don't they? I love this sort of this that I've heard from politicians on the left, that your case proves that the law works. You know?
Well, that's completely incorrect. If anything, it shows that 18D wasn't engaged by the Human Rights Commission when dealing with any of the students, and it wasn't even engaged by the judges.
Yeah.
At first instance, the judge said that he wasn't going to make a determination on whether or not 18D was in effect. I think. It's been a little while since I've read the judgment, though, sadly. So,
yeah, but then I think in the dismissal of the appeal, if I remember reading correctly, the judge did obviously, he said, like, especially the comments about the white supremacist lab, that was quite clearly meant sarcastically, and that's really the only way that it could be taken. I remember reading that. But there's another part here to the law. So just for those that don't know, I'm going to read it out. And most people would have heard this in Australia by now, but basically Section 18C says, it is unlawful for a person to do an act otherwise than in private if A, the act is reasonably likely in all circumstances to offend, insult, humiliate, or intimidate another person or a group of people, and the act is done because of race, colour, or national or ethnic origin of the other person, or some or all of the people in the group. So most people focus on the language, which is offend, insult, and humiliate. And most people most reasonable people react well, it's quite ridiculous to have a law around the subjective feelings of somebody. Anyone can be offended by anything. We can all claim offence. But the aspect that I want to get to that's not often talked about is that the standard of evidence here, there are often tests in law, for example, the reasonable person test, but this law in particular is not based on what a reasonable person of the community would think, like an Australian person. It's based on what a member of the group that is allegedly being offended, insulted, or humiliated would think. So in this case, in your case, it's what a member of the Indigenous community would find offensive, humiliating, and insulting. And so you effectively, you've set up a law here that treats people from different groups differently. Is that a correct reading?
I'd say that's pretty correct. I will give at least one benefit to it. It is a reasonable member of that group.
Yeah.
So it's not someone from the fringes or an extreme person. They try to at least get that component. But you're completely right. It does treat different groups differently. So it would treat a Jewish complaint differently to a complaint from an Indigenous person. A complaint by an Indian person would be treated differently again. And it's not necessarily in line with what Australian communities would think. So at the end of the day, if a law like this is going to exist, which it shouldn't, we need to be having a consistent test so that you know how it's going to be applied. You look at the case law and you'd have different outcomes based on Indigenous groups compared to the Jewish groups. And if any members of Muslim people made complaints under 18C and they got accepted and went through the courts, which hasn't occurred at this stage, but it's possible, they would be treated differently again. So, yeah.
Well, in the case of you brought up the Jewish community. So, for example, in Europe, there are certain countries that have, it's illegal to deny the Holocaust, for example, which I think are ridiculous laws. I mean, I think if you're that much of an idiot that you want to deny the Holocaust, you should say it in public so people can roundly criticize you. But essentially, could 18C be used in that way by, say, the Jewish community? If someone publicly says something about Holocaust denial, then, it's race-based, and a Jewish person would obviously take that much more offensively than any other person in the community. So doesn't this open up the can of worms that you were just sort of talking about?
I believe it's already been used like that.
Right.
Quite a number of the successful 18C cases have been prosecuted by the Jewish groups. And I believe one of them was to do with someone's publications about the Holocaust.
Right.
Or Holocaust-related things. And I agree. I would much prefer to see who's denying the Holocaust or see who's a legitimate racist, not thrown around, but someone that has a hatred for people based on their race. I'd like to know who they are.
Yeah.
So that I can either tell them that they're ridiculous or so that I personally can avoid them.
Yeah, exactly.
Laws like this don't stop people thinking or believing these things. They just push them underground. And when you push things like this underground, you don't get any discussion, and they get an echo chamber around their views.
Yeah.
And they think that what they think is correct because everyone they know thinks that. And you're wrong, not them, which is incredibly dangerous.
And what do you make of this criticism that you often hear? Again, I've heard, again, it was Labor politicians that say this kind of thing, that saying you want to do it away with 18C, then they'll come at you and say, what are the racist things that you want to say? What are the, that's a common refrain from the left.
People shouldn't have to justify how they're going to use their freedom of speech before they use it. That's the main concern there. I shouldn't have to say to a politician or to an elite who's been elected as the president of the Human Rights Commission, not elected, sorry, appointed by a bureaucrat. I shouldn't have to say to them, look, this is what I want to say. Is this okay?
Yep.
And I can answer that question of what do you want to say that you can't say under 18C. I'd like to be able to say things without the fear of legal repercussions. I want to say things about segregating people based on their race, about Indigenous violence and Indigenous child issues, because these are serious issues that are occurring in Australia. And people are afraid to talk about them because you say something about segregation and you end up having a complaint lodged against you like Alex did. You say something about Indigenous parenting issues and you end up with a complaint lodged against you like the late Bill Leak had against him. So these are the things that I'd like to be able to openly and freely discuss without the threat. It's not about whether or not a complaint makes it all the way through court. It's about the process and being dragged into the Human Rights Commission and effectively extorted for someone's monetary gain over comments that are not in violation of anyone else's rights. It's just a restriction on someone's free speech for the sake of it. Yeah.
Yeah, it seems to be, it's the old quip that paradoxically a lefty made, which was Noam Chomsky, which he famously said, if you're not for free speech for those that you despise, then you're not for free speech at all. You can't be just for free speech for the people that you agree with or the opinions that you approve of. But that seems to be sort of the line taken by the law and the Human Rights Commission.
Yeah, I think personally that freedom of speech shouldn't be restricted unless your freedom of speech impinges on someone else's fundamental human right. And that's the only time that we start looking at which right needs to be curtailed. And it may not always be free speech. Sometimes you say, well, freedom of speech should outweigh that right. But there's definitely no right or fundamental human right to not be offended, to not be insulted, and to even not be humiliated.
Exactly.
I could say that it's probably fair to say people shouldn't be intimidated based on their race, but that's completely different language to offend, insult, and humiliate. Yeah,
but I think and you're much younger than me, so you're probably closer to this than me because it's only a few years since you came out of high school and things. But I think our society has become, with all the anti-bullying and things, the idea of offence has taken such precedence over freedom of speech, for example. I mean, we went to school, when I went to school, it was sticks and stones break your bones, names won't hurt you. People will say offending things to you. That happens. That's life. You get over it. But today we put people's feelings ahead of facts, evidence, debate. And rather than say, look, this might hurt your feelings, but we got to get the truth out there. That's what's more important. So how do you feel about, I mean, it's hard for you to compare because you didn't go through to school when I did 25 years ago, but how do you feel that the school environment, and particularly the university environment, sort of inculcates this environment of non-offense?
I feel like it's a real concern. We're going to end up with university graduates that don't actually have fully fledged critical thinking skills. Without being exposed to ideas that might offend you or might be uncomfortable or controversial even, people aren't able to form their views or understand the views of others. And it's just going to create this world where everyone thinks the same because that's what we've been told to think.
Yeah.
And if you think anything else, you're chastised, you're dragged through the legal system, you're socially censored, which might be an okay thing to have, the final one. But we shouldn't have governments, institutions, and bureaucracies forcing views onto people or removing the opportunity for people to have other views because it might offend someone.
All right, so let's go back because we kind of got off the track. Yeah, so let's go back to July 2015. You're given 3 days notice that you're going to have a hearing. Now, you decided to defend yourself as someone who's not flush with cash. You don't have a lot of money. You don't come from a wealthy background. You decide to defend yourself, but then I think it was, who was it? Tony Morris stepped in.
So what happened was, firstly, the Human Rights Commission weren't even the ones to contact any of us. They left it in the hands of the university. The university contacted us not by phone. They sent us an email. I emailed them back the next day after sleeping on it and rewording the angry email to a little bit more of a reasonable one. And I got a response of, we'd prefer to talk on the phone. So red flag number one, when they don't want to put anything in writing.
Yeah.
I called them and they were pretty much trying to stop me from going. They were saying that it's not compulsory. The university's been dealing with this for a while. Nothing's probably going to happen. You can go, but you don't have to go. So that was red flag number two. This is a pretty serious thing, being alleged to have racially vilified someone and being in the Federal Human Rights Commission.
Yeah.
So I went along to the conciliation conference by myself, which was a pretty big waste of a day. A lot of it sitting in a room by myself, occasionally having someone come make sure I was still there. A brief conversation in the conciliation room itself, in which I said that I hadn't done anything, which was the first time that anyone at the Human Rights Commission had heard that. And the first time that this woman's lawyer had even heard it, because it was the first time I'd had a chance to say anything.
So they just assumed that this Facebook post, which was under your name and had your photo, was you because of that reason. They didn't even entertain the possibility that someone had created a false account, which is obviously pretty easy to do on Facebook.
Yeah, exactly. There was no thought in their mind that they could have got this wrong, or that I was telling the truth. It was obvious to them that I was just a kid and a liar, and that I was going to get what I deserved. So it didn't settle in conciliation, obviously. Documents were filed in the Federal Circuit Court, and we had the first hearing was in December of 2015. So this was just a directions hearing. Despite what a lot of people seem to think, I'm not very well off. I'm not some liberal trust fund baby. I'm from a low to middle class family who always voted Labour, surprisingly. Despite what Crikey have asserted about my political leanings. So I couldn't afford, to pay the $5,000 that I was asked to pay to confidentially settle this, or I couldn't afford a lawyer. I tried to go to Legal Aid Queensland. I tried to go to some of the legal aid centres, and I was turned away because they don't help respondents in racial vilification cases. So I had to go by myself. Daunting and probably a really stupid idea to self-represent with no legal experience. But I just stood up in front of the judge and said, I haven't done anything and I don't know why I'm here. Sadly, that didn't work. He said I needed to get some kind of evidence, and made some directions about how people should put in for strikeout. Luckily, in February of 2016, Tony Morris QC became aware of the case through a group called QUT, which is a public law clearinghouse, who were trying to help Jackson Powell, one of the other students, get some representation. So Tony picked Jackson up pro bono, well, for no payment from us.
Yeah.
And then he saw that I was in a similar boat with no representation and reached out and asked if I would like him to represent me.
Yeah.
So that happened in February. And without that, honestly, I don't know how this case would have gone. We might, in fact, still be in the court.
Yeah. Yeah. So that, I mean, that's strange, isn't it? I mean, you had no evidence other than saying I didn't do it, but surely the burden of proof is on the plaintiff, since their only evidence is, okay, here's a post with the guy's name and his photo, but that obviously could be an impersonation. So that, I mean, to actually prove that it's you, wouldn't they need ISP addresses, and wouldn't they need to be able to prove that it came from this room and this PC and all of that kind of stuff, and that it was separate from your own Facebook profile if you even had one? Or, I mean, wouldn't they be the ones that have to supply more proof? Because I think, if I read rightly, the reason yours was thrown out is because they didn't actually have any other proof other than here's a post by a guy alleging to be you. That's it.
Yeah. So all they had was, it wasn't even the post, it was a printout of the post that had been photocopied a dozen times.
Yep.
They attempted very late in the proceedings, after we'd gone for a strikeout hearing, they attempted to subpoena Facebook to get the details. And this is the kind of thing that they should have done.
Yeah.
Facebook has this kind of information, I assume. And they quite easily could have said, this is the account that made the post. This is when the post was made. Here's the IP of the post. This wasn't a criminal proceeding where it had to be beyond a reasonable doubt. It was on the balance of probabilities.
Yeah.
So they bring some very limited evidence, and we had to bring evidence in the contrary. So on the strikeout application, we put everything that we could, showing where the picture from the profile came from, because it was a picture taken for a nightclub, showing that I'd attempted and successfully gotten this Facebook page shut down.
Yeah.
Showing the activity log from my actual Facebook page, as much as we could, to show that it was incredibly unlikely that I'd done anything. Then the shoe was on the other foot, and they had to bring some evidence to dispute this. And if they'd brought anything, any evidence at all, it wouldn't have been struck out and it would have gone to trial.
Right.
But they decided that, well, it wasn't so much a decision, they just didn't have any evidence. They couldn't bring any evidence. So they went to the strikeout application solely with this photocopied screenshot of the post.
That seems like pretty, I mean, I'm not a lawyer, but it seems like pretty sloppy work, isn't it? I mean, so they've just assumed that it was you, but they didn't assume the possibility that it was fudged, that somebody else made it. They just assumed it was you. They didn't bother getting more backup evidence than a photocopy of something that was on the screen once. That's it.
There's a few things that I think are at play here. There's a change in how technology works. Some of these people, lawyers who've been lawyers for a while, are from a time where Facebook didn't exist, or the internet was a very limited thing. So catfishing people wasn't something that they'd ever heard of. Making fake Facebook profiles of your friends as a laugh wasn't something they'd ever heard of. These are all things that are common. Or parody accounts, people do that all the time on Facebook and Twitter. So they're from a different world where, well, why would someone make a fake Facebook of you? That sounds like a lie. Yeah.
I just wonder how, as an aside, how the law can actually keep up with this stuff, because it just changes so rapidly.
It's something needs to change, and this, at least, the this case has shown a sort of standard that's required for using social media to prove someone did something.
Yeah.
You need more than just a screenshot of the Facebook post. You need connection to the profile. You need to then sort of prove who the profile is actually run by. So at least an upside is that we've got some certainty there now. But catching up with social media is always going to be a cat and mouse kind of game.
Sure. So we're at February 2016 now, and Tony, sorry, I keep forgetting his name, Tony Morris.
That's it.
Stepped in. How do things proceed from there?
So at this point, the media has slowly become aware. Hedley Thomas from The Australian was writing a lot of pieces, trying to get to the bottom of what was going on with this. It wasn't until probably November that anyone else caught on. So we put in for a strikeout application that was in March. So that was heard by the judge, and he reserved his decision. I will right now say that the Federal Circuit Court in Australia is one of the busiest courts, which is part of the reason for the serious delay between March and November for us getting a judgment. Maybe the government can throw some money their way, but I can't see that happening. So then we had to keep carrying on with the timeline towards a trial, regardless of us having the strikeout application. So we went to a court-ordered mediation, which involved the lawyers for this woman throwing documents across the table that they thought would sort of prove bad character, or prove that I was hiding under false names and stuff like that. There was a lot of rhetoric thrown around about the other students and where their houses are, implying their social worth and the kind of political leanings they have. So at one point they were trying to say that this whole thing was a political stunt, because it was so close to Reconciliation Week. So obviously there was no settlement in this mediation. And we decided to start pursuing the Human Rights Commission to see what they, or to get to the bottom of this delay. 14 months was just such an abnormal amount of time that we actually lodged a complaint against the Human Rights Commission, alleging violation of our human rights. That's been wound up now, but we came to understand a few things. The first is that despite the president of the Human Rights Commission having very limited roles that she actually performs for the $400,000 a year that she gets, one of the roles is that she is to be accountable for the complaint handling process. And all complaints must be directed to the president to be signed off on. However, their actual procedure involves it going to a delegate of the president, and the president of the Human Rights Commission has no oversight over the complaint handling process within the commission itself. We also determined that the commission doesn't make determinations about whether 18D is in effect. This was a concern with Bill Leak. But they decided that that's not for them to decide. All they are trying to do is put the parties in the room. So their entire goal seems to be to conciliate as many complaints as possible, regardless of if there's substance to the complaint. Say that they've got really good numbers, really good percentages, and then ask for more money from the government.
So, I mean, the idea of the Human Rights Commission set up is to conciliate so things don't go to court, so they don't end up in lengthy court battles and costs that people can't afford, and these things can be worked out much easier. But that's the intent. Well, I think that's the intent, but the effect is actually not. It actually has an opposite effect in the sense that it becomes, it essentially becomes a shakedown agency, doesn't it? Look, it's easier for you to pay to make this go away. A little fine here, and I think we found out through the Australian last year or early this year that so many $1 million has been paid in these types of cases just so they'll go away. So conciliation is a word that suggests people sit down and have a discussion and work it out and walk away, which I think does happen sometimes. But it's actually a little bit more pernicious than that, isn't it?
I'm sure that some of the complaints that get conciliated with a simple apology.
Yeah.
But a lot of the time, you end up having corporations or big companies involved, as it's their employee that's done something. They may be vicariously liable.
Right.
And if they're going into a room with someone and this person effectively says, look, if you don't give me this money, I'm going to make public that your employee is a racist, which means your company is a racist. Yeah. Do you want that bad publicity? If not, is it worth paying this? And it ends up becoming an economic decision where you look at the bad publicity, the estimated legal fees, and you go, well, they're asking for less than that. So we'll just write it off, give them the money, and it'll all go away.
Yeah. And
it also means it's all confidential, and we never find out what is actually determined to be breaches of 18C.
Yeah.
So we've seen what the court's determined, but we've got a lot of things that are occurring in the commission that are completely confidential, and we don't know what the commission's determined might be a breach, or what settles because someone thinks, oh, this is too close to a breach, and it's not worth the fight.
So so a lot of this comes down to the culture in the AHRC, and if you have a culture of sort of activism, if you like, that's what it's going to promote. And
exactly.
Yeah.
And I don't know if changing the president will fix the problem, because as we've seen, the president in this situation for the complaint handling is a figurehead. They don't actually get involved like they're meant to. So the people making the decisions are these senior bureaucrats who no one knows who they are.
Yep.
They're not really accountable to anyone at this stage, and they're definitely not elected by the Australian people. And these are the ones making decisions about if a complaint's trivial, if a complaint should be conciliated, and how to treat complainants compared to respondents, leading to all sorts of shakedowns occurring.
Yeah. Yeah. So again, the old story. It's the road to good intentions is paved. I've completely ruined that, but you know what I mean.
I know exactly what you mean.
Yeah, it's they've got good intentions, but they completely screw the pooch, and it ends up being worse than the actual intention. So, I mean, for my way of thinking, I think a lot of people just think that the Human Rights Commission should be axed. I mean, is that what you think? I mean, is it worth tinkering with procedures in the Human Rights Commission? Shouldn't we just get rid of it?
I think that we need the government to come out and actually explain what the role of the Human Rights Commission is at this point.
Yep.
Back when it was the Human Rights and Equal Opportunity Commission, and they had determinative powers that were then deemed unconstitutional, they had a role where they took the complaint handling procedure out of the hands of the court to remove some of the burden. And they made the decisions. That was decided to be completely unconstitutional, and it could only be a court that made these determinations. But the commission wasn't axed. The commission was kept as this pseudo gatekeeper, pseudo trial that you'd then have to go through again anyway.
Yeah.
I think that there's some benefit to the inquiry functions the commission has that, when handled correctly, lead to inquiries into human rights and human rights violations within Australia that are very important. But the way the complaint handling procedure for these kind of racial discrimination, disability discrimination issues is handled, I think there's no benefit to the commission being there for that, and that it could be handled through the AAT or the Federal Circuit Court just as easy.
Yep. Yep.
Plus, we get some more money into the court if we take it away from the Human Rights Commission, which could also be helpful.
Yeah. I mean, the Human Rights Commissioners are pretty well paid. So we fast forward to November last year. I think I remember doing a video about this when you were vindicated. It was thrown out. Yep. And then there was an appeal subsequent to that.
Yep. So there was an appeal to the full court of the Federal Court. However, there was some confusion on the part of the other party as to how long they had to make the appeal, because it was off of what's called an interlocutory, not a final judgment. They only had a shorter period of time, and it was a leave to appeal, so they had to actually ask the court if they were allowed to appeal. So they ended up appealing late, almost making a very bad decision by trying to blame the first instance judge for misleading them on how long they had for the appeal, which is not a good move for any legal practitioner to make. It's your responsibility to know the rules. It's not the judge's responsibility to tell you what to do. Luckily, they dropped that before the appeal. Otherwise, it could have gone particularly bad for them. But on the appeal, they ran some ludicrous arguments saying that any form of negative discussion about affirmative action should be illegal under 18C. It should be unlawful, and you shouldn't be able to critique affirmative action because it may offend those who are beneficiaries of affirmative action. So that means thankfully it wasn't accepted, but if that view was accepted, that means that nobody, not even the Prime Minister, would be able to talk about whether or not affirmative action is working correctly. So we could never actually review things like this, and we could only ever keep increasing it.
Yeah. So, for example, then you could never criticise, for example, quotas for as they do have in South Australia now. They have a quota for getting, say, 50% of the police force female. So you wouldn't be able to criticise that quota.
Or Indigenous quotas, or quotas for other ethnicities. So not being able to criticise these things is a horrible idea, because we should always be able to criticise or critique things that are happening. Otherwise, how can we be sure that what's happening is the right thing to do?
And further to this, I think it's quite clear that the other side of politics, the left side of politics, wants to consolidate this act with all the other discrimination laws such that they would fall under the same rubric. And therefore you would have, in this case, 18C refers to race or ethnic origin, but we would be talking about religion here, or gender, or anything, maybe, the gay community, LGBTI issues, all of that would be consolidated under it. So, for example, if somebody was offended on the basis of, as you brought up before, religion, if you're a Muslim, this is where the left side of politics wants to go with this, and that's pretty pernicious. It's
pretty scary. Mark Dreyfus, QC, the Shadow Attorney General, came out and said that if Labor gets into power, they'll be looking at whether or not we should set a general standard of speech. So instead of protecting free speech, they're looking to curtail it even more. This shouldn't be a left-right Labor liberal issue. This is a fundamental issue that we as a liberal democracy should have free speech, just like we should have freedom of religion, freedom of expression, and freedom of conscience. So if you start curtailing them, we're not a liberal democracy anymore. We're an authoritarian state.
Absolutely. But there's plenty on the left, I think, that would actually like that state of affairs, unfortunately. I'm pretty sure I know the answer to this, but what do you think about Gillian Triggs getting a free speech award?
Well, at first I thought that was just a complete joke. When I found out about it, I laughed for a good solid 5 minutes. It is a complete disgrace, and it really shows the true colours of Liberty Victoria. They may claim to be a civil liberties movement, but really they are just an identity politic movement, a virtue signalling movement, and this is just their way of sticking the finger up to the government, to News Corp, to Bill Leak's family, that Gillian Triggs, who's not once stepped in to defend free speech and has actively tried to curtail it, saying that it's a shame that we can't control what people say around the kitchen table. This woman getting a free speech award is just completely backwards.
Yeah, she embodies everything to me that's wrong with sort of this elitist view that they have to condescend to the rest of us to tell us what is and isn't respectable to say around a kitchen table. I mean, that just, to me, it's the height of arrogance and condescension to lecture people about the way they should speak in the privacy of their own homes.
Well, it's borderline Orwellian.
Mm.
What are we going to have telescreens in every room so that the Human Rights Commission can monitor what we say? And if we step outside of the groupthink, we're dragged off to be rehabilitated? This is just ridiculous.
Yeah. Yeah, it is. We're coming up to an hour. So what the last couple of questions I want to ask you is sort of what's going on with you today. But before we get to that, could I ask you, what is the state of Indigenous computer labs at QUT today? Have they been done away with? Have they been made so that, at least are they signed if they're going to have them? What's this?
At this point, they are signed. There's 2 of them, I believe, or 3, because there's 3 campuses becoming 2. They're completely signed and they are swipe card access only. So if your ID does not allow you access, you are not allowed in the room. This may change when the Vice Chancellor Peter Coldrake leaves, because this was his pet project, which explains his attitude to it publicly. But at this point, they still exist. I've decided it's best not to go near either of them, just in case.
Yeah,
but they're completely signed and they're still there. Has
there been any public discussion on the university campus about this idea? Just going back to what Alex Wood said. I mean, how do you, we're supposed to be living in a world where, inclusive is one of the buzzwords, and yet we're going to segregate a lab off for Aboriginal people only, or Indigenous ancestry only. Has this even been discussed at the level of students? Has there been any input from students? Or, I mean, how has this gone forward? You just said it was a pet project of the current president?
Yeah, the current Vice Chancellor. So at this stage, I believe that any attempt to discuss this has been completely suppressed. The Facebook page where Alex posted his comment for the longest period, and I'm sure still now, have a ban on the words 18C, the Ujura unit, any of that. And if you mention it, you get banned from the group. Complete suppression. So I'm studying law at QUT now, and there's not been a peep about it from any of my lecturers, any of my tutors. They don't even know what's going on. I had it get brought up by another student who was a friend of mine, and we had to spend time explaining to the law tutor what had occurred in the past year. So it seems everyone at QUT has put their fingers in their ears and hoped that this whole thing will just disappear.
Yeah, the ostrich head in the sand syndrome, isn't it? Exactly. So just on that, then let's talk about you for the last few minutes. I mean, you were, if we go back to 2013, you were an education student in your first year?
Something like that. Last year I had about a year to go when I decided to stop. So I was planning on becoming a high school teacher, majoring in biology. I'd done a few prac placements at places with surprisingly high Indigenous populations and was applying for positions already out into rural and remote areas that are very heavily Indigenous. When this all blew up, I had a lot of conversations with my parents about it and about the impact of having the word racist anywhere near me, and made the decision that this would follow me for the rest of my life. And I can't risk, as a male teacher especially, having students start asking questions about whether or not I'm a racist.
Yeah. So
I made the decision to apply for law. Yep. I got into law last year and have then since started working for Tony Morris as his managing clerk. I work for him 4 days a week. I study when I get an opportunity. Sometimes I get some sleep, but you've sort of got to balance things. And I'm doing a few little events. I've got a couple of events coming up in Brisbane where I'm going to be doing some speaking.
Yep.
And maybe a couple down in Sydney, which will be good as well. Just trying to keep a focus on free speech and expanding out into other fundamental human rights that are being curtailed in Australia.
Yeah. Well, that's great. I mean, we certainly need advocates like you, and I don't think there's anyone in a better position than you, given your experience. Do you want to throw out any of those dates, or any of those dates firmed up? Any of those events?
They're not firmed up yet. There's looking like there's one in October up in Brisbane. So people keep their eyes out for that. It'll be a big event that's going on, and there might be one in August as well.
Yep. Okay. Well, mate, thanks a lot for sharing this story. I really appreciate it. There's not many. It's an unfortunate state of affairs that whilst most people sort of take free speech for granted, there's not that many people out there actually advocating for it, which is unfortunate. And I appreciate all you're doing for the cause. Thanks for coming on today.
Thanks for having me. Thank you very much.
Thanks, mate.